Hi there, everybody. This is Samantha from the Law Offices of Samantha Wolfe. We're located at 20 East 6th Street, Suite 206 in Waynesboro, PA. And you can reach us at 717-655-2676. And today I wanted to give a brief summary of the healthcare power of attorney, the living will, and the mental health power of attorney. Now, just as a way of information, I have previously recorded something regarding the financial power of attorneys. It's about 30 minutes. So you're welcome to go check out that video as well. But I thought it would be helpful for us to break it down into the different powers of attorneys so that you could have a step-by-step if you happen to be looking at your document at the same time about what should or should not be in the document. So with that being said, I wanted to take a few minutes and devote it to those healthcare power of attorneys, the living wills, and the mental health power of attorney. So I'm going to share my screen here so that we can all follow along. Okay. This is a picture of our office as you would walk in. So again, we're in the Landis complex at 20 East 6th Street, Suite 206 in Waynesboro, PA. And our number is 717-655-2676. At our office, we do offer free initial consultations. So we usually block an hour and a half off. You can bring any documents that you want. We're happy to review them with you while you're there. Go over what changes you may or may not want. Okay, so we've talked before about the power of attorney documents in the last will and testament. They make up our hot five. So we have the 4 power of attorneys, the financial power of attorney, which we did a separate video for. And then we have the healthcare power of attorney, the living will, the mental health power of attorney. And then, of course, the last will and testament. Now, remember, the power of attorneys are effective while you're living. If you're unable to make decisions, it's your power of attorney that would make those decisions for you. The will is once you've passed away. So once you've passed away, how do your assets get divided and who's in charge of doing that? That's under your last will and testament. But the power of attorneys are while you're living, really making sure that what's being done is in your best interest. And like I said, we have a separate video on the financial one. So I just wanted to focus today on the healthcare power of attorney, living will, and the mental health power of attorney. Now, I did want to mention that a lot of times people will come in and they will ask the difference between a post and a power of attorney. And so I wanted to address that right here at the beginning. So know that in Pennsylvania, we have what's called an advanced healthcare directive. And an advanced healthcare directive is typically comprised of a healthcare power of attorney and a living will. A lot of attorneys had done them as one document, and that became the advanced healthcare directive. And so I get a lot of questions about, well, do I need a post if I had to have an advanced healthcare directive? And POLST is something that typically you're going to fill out with your physician, your doctor, and POLST is POLST in all capital letters, and it stands for Pennsylvania Ongoing Life-Sustaining Treatment Options. And it really outlines, what end-of-life decisions you would want. And what I recommend is that everybody have an advanced healthcare directive. Everybody should have a healthcare power of attorney and a living will. And remember, those two are what comprise the advanced healthcare directive. But for the POLST, I recommend that people who have a diagnosis or who are nearing end of life and want to actually have those end-of-life orders. A POLST is actually a physician's order that goes as part of your chart and is saying that you do or do not want certain things. I don't recommend everybody have a POLST because a POLST really is just saying, you don't want like CPR, breathing machine, all of that. But for most of us, unless we have a terminal diagnosis, we are going to want to leave that up to our agent because depending on the circumstance, they may want to consent to certain things and not other things. And with a POLST, like I said, that's a physician's order. So again, I recommend everybody have an advanced healthcare directive, which is a healthcare power of attorney and a living will. And those that have a diagnosis or where the physician is saying, you really do need to have these end-of-life decisions as part of your medical record as a physician's order, then you do a POLST. But for most people, I would not recommend a POLST. So like I said, the healthcare power of attorney and the living will comprise the advanced healthcare directive. We actually have them as 2 separate documents in our office. And the reason why is that the healthcare power of attorney legally is effective if you cannot express your wishes, but it doesn't have any end-of-life decisions in there. So the living will is the one that's if you can't express your wishes and you have a terminal diagnosis with no realistic hope of recovery. So we actually have them as 2 separate documents. So you will have a healthcare power of attorney attorney, and then you will have a living will. Two separate documents. Again, together, they make up the Advanced Healthcare Directive, and some attorneys put them together, but we actually put them as separate documents. So what is a power of attorney? A power of attorney is a written legal document where one person, the principal, that's what their title is, authorizes another individual, the agent, to act on his or her behalf. This is so important in Pennsylvania because if you don't have a written power of attorney, whether it be financial or healthcare, then technically under law, somebody has to petition a court in order to have the right to make those decisions. So a power of attorney really empowers you to be able to say who you want to make those decisions without having a court get involved. So there are 4 types of powers of attorneys. Like I said, we have a separate video for the financial, but then we have a healthcare power of attorney, a living will, and a mental health power of attorney. So again, 2, 3, and 4 are separate individual legal documents that we recommend at our office. And we're going to go through each one and explain why. So we have the healthcare power of attorney. The healthcare power of attorney is something that governs if you have health issues and you're unable to express your wishes to the physician. So remember, as long as you're able to express your wishes, it's always what you want. The only time the healthcare power of attorney comes into play is if you're unable to express your wishes. And expressing your wishes can be anything from a verbal expression, but it can also be blinking an eye, squeezing a hand, or writing something. So again, it just requires the doctor to say, no, they're not able to express their wishes. So again, that's when the healthcare power of attorney comes into play. The importance of a healthcare power of attorney is it authorizes the agent to make medical decisions. So that could be consenting to surgery, to admitting or discharging you from a hospital or nursing home. And then we actually include the medical records, the HIPAA release, the federal rule, the regulation. We actually include that right in the document. A lot of times clients have a primary care physician and they'll have filled out a HIPAA release at their primary care physician saying who can access that information. But we put it in the document because that way, no matter where our client is, whether it's their primary care physician or whether they're in a hospital, the agent can access that information. Because again, if you haven't been to a hospital, that particular hospital, or it's not in your system, your coverage system, there may not be a signed HIPAA release on there. And so again, we put it in the document so that your agent can access that information, can talk to the doctor, can ask information regarding your diagnosis or prognosis. And then your healthcare power of attorney typically has organ donation, or we put cremation requests in there as well, because we don't want it to be after you've passed away, because sometimes there are certain things that have to be done in order for you to be able to be cremated or for your organs to be donated. So we always put that in the healthcare power of attorney. Now, a couple of things about organ donation is that in recent years, for example, if you have organ donation noted on your driver's license, that just means that you can donate, or that you're consenting to donating major organs. But recently in Pennsylvania, when I say recently, within the last 2 years, they did say that if you want to be able to donate tissues, things like corneas, those type of things, you actually have to specifically put that in the document. So if you just have organ donation, then that really doesn't do anything other than the major organs. We actually want to have in there about tissues if you want them to be able to do that as well. That's also important because a lot of times people will put about how they don't want life-sustaining treatments. And a lot of times if there's organ donation there, especially with tissues, you may have to be, in order for them to be able to harvest it appropriately. So I always like to have that discussion. So again, even if you haven't noted on your driver's license, it's still a good idea to have it in these documents, because this is what's going to be at the hospital. So again, it kind of clues everybody in as to what your wishes regarding your remains would be. The other thing I wanted to mention here is that typically when we have a healthcare power of attorney, we're naming an agent, and we can name one individual, we can name 2 individuals. If we're naming multiple individuals, you have the option to say they have to make a decision together. It's a joint decision. They have to be of one mind, or you can say either one of those individuals can make the decision. So you can set it up either way you want. We also have done it where we've named like 3 people and said it has to be a majority, so 2 out of the 3. If you're naming somebody as your agent, again, we're putting a HIPAA release in the document so they have access to the information, but we're also able to grant a HIPAA release, the access to the information for somebody who's not an agent. So for example, I have a sister who lives in Pittsburgh. So although my parents haven't named her as their agent, what they have done is given her a HIPAA release saying that if, she would call and ask the doctor certain questions, that the doctor could communicate with her. So we do that a lot of times with out of state children or agents who, again, you may not actually be naming as the person making the decision, but you do want them to be able to call and get updates, again, from a nursing facility, from a hospital, for anyone like that. So you can also do that in your healthcare documents. So if you happen to have an older healthcare power of attorney or you've executed a document prior, I would encourage you to look through to see, is there a HIPAA release in there? How do they handle that in the document? And I would encourage it to actually reference that 1996 federal regulation. And then, like I said, if you're an organ donator or you've designated organ donation on your driver's license, you want to make sure that's in your healthcare power of attorney as well. So the healthcare power of attorney is effective during your life. When you pass away, then this document is no longer effective. And usually in our healthcare power of attorney, what we're doing is we're granting access to information regarding the principal's physical or mental health so that the agent can make decisions dealing with that. That allows them to employ or discharge any type of hospital support personnel that would be responsible for care for the principal. We do allow them to authorize, withhold, or withdraw medical care and surgical procedures. And again, that's only if you're unable to express that in some way. We do protect your right to privacy, which just means that if your agent is consenting to certain things, we have a clause in there that says, they're allowed to do that. They don't have to provide justification for why they're consenting to certain things, but not other things. We do allow your agent to grant any releases to the hospital staff that they may need. And then we do allow them to authorize or admit or discharge you from any type of medical or support personnel that would be responsible for your care. In Article 3 of our document, Article 3 is solely devoted to the HIPAA release, and we have all of that language in there as well. Usually under the healthcare power of attorney, your agent can be compensated while they're serving, so we have that language in there. And then this document, unlike the financial power of attorney, it does not require your agent to sign it, agreeing to be your agent. So in the financial power of attorney, the principal, the person who's drafting or appointing an individual, for example. So if I have a power of attorney and I'm appointing my sister, I'm the principal, my sister is the agent. Under the financial power of attorney, it would require my sister to sign it before she can serve. In this case, under the healthcare power of attorney, my sister would not need to sign in order for her to serve. So although we encourage, especially if you're naming children, not to have your kids sign under the financial power of attorney until they would need to serve, for the healthcare power of attorney, it's perfectly acceptable to provide your kids to, as well as the hospital medical staff, a copy of your healthcare power of attorney so that they have that on record. Okay, the next one is the living will. So again, even though a lot of times I see it where the healthcare power of attorney and the living will are one document that comprises the Advanced Healthcare Directive, in our office, we actually have a separate living will. And the reason is because legally the living will is effective if you cannot express your wishes to the physician and you have a terminal diagnosis with no realistic hope of recovery. So the living will is where we have a lot of end-of-life decisions. So we don't have that in the healthcare power of attorney because that's not in a situation in which you're terminal. That would be, you're expected to make a recovery. So in the living will, what we do is we outline what you would want or not want. And again, the living will is effective while you're living. As soon as you pass away, then we are under the last will and testament. So in the living will, typically it's going to express your wishes regarding end-of-life decisions, regarding terminal conditions if you're unable to give directions, and you're going to be designating if you want artificial nutrition or hydration. We do include the HIPAA language in this document as well, and again, that allows access to information, and you can have multiple people receiving information even if they aren't appointed as the agent. And then we typically have organ donation, cremation requests in the living will as well. So we have both the organ donation and the cremation requests in both the healthcare power of attorney and in the living will. So in the living will, remember it's effective if you cannot express your wishes and you have a terminal diagnosis. And what we've noticed is that as people age, we're living longer, but most people would say, well, if I can't express my wishes and I have a terminal diagnosis, I would want to be receiving pain relieving drugs if I'm in pain in order for me to be kept comfortable. And my question is how are we going to make sure that we designate that? So the reason why this is important is sometimes in order to deliver those pain relieving drugs, or even if the doctor determines that you're dehydrated, they may say that we need hydration to be able to be administered for you to be kept comfortable. And a lot of times I see power of attorneys that here's like in this example, say that artificial hydration, that would be something that you would prefer not to have, or that they would be withdrawn. But what we actually recommend is we recommend that we distinguish it. So we would say, I'm okay with pain relieving drugs of any kind, or any medical or surgical procedures that would be calculated to relieve my pain. And that you're okay that you be given artificial hydration, even if that means administering it through an IV in order to deliver those pain relieving drugs. So if artificial hydration is needed to keep you comfortable, you're okay with that. So that's a distinction from what most people have in their documents. But we want to be really help your agent be an advocate for what you want. And so if you want to be kept comfortable, we want the language to look more like this, okay? But you're going to see under letter B, you're saying you don't want any life prolonging procedure. So again, this is if you cannot express your wishes to the physician and you have a terminal diagnosis with no realistic hope of recovery. You're saying, I'm okay with pain relieving drugs being administered, but you're saying you don't want any life prolonging procedures. And so that would be CPR, a breathing machine, dialysis, surgery, chemotherapy, radiation, antibiotics, and a feeding tube. Now, I want to make this distinction because I think this is important. So I've actually seen it in a couple of real life examples where the antibiotics comes up and, would we want the antibiotics to be administered. And what I want to remind you is that this is if you cannot express your wishes and you have a terminal diagnosis, and the doctor determines that this is a life prolonging procedure, which just means that the doctor has to say that the antibiotics aren't going to clear this infection, that you're going to be on antibiotics and then eventually pass away. That in this case would say that you wouldn't want antibiotics in that situation. But if the doctor can say that it will most likely address that issue and that, you will be able to recover from that, then antibiotics wouldn't fall under, or we wouldn't be dealing with a specific situation. So again, this is only if you can't express your wishes, you have a terminal diagnosis with no realistic hope of recovery, and the doctor is saying that, antibiotics would sustain your life. And the best example I can give you is someone very close to me had COPD towards the end of their life. And so they would get pneumonia and be on antibiotics all the time. They couldn't ever get off the antibiotics because the infection wasn't clearing at that point. And so in that case, antibiotics would be considered life prolonging, meaning that if we took the antibiotics away, the person would pass away because of the pneumonia. So in that case, antibiotics under this situation would say you don't want them. But if it had been another infection, like an ingrown toenail, something like that, that the antibiotics would have cleared the infection, then you're saying that you would want them under those circumstances or in that situation. So I hope that explains it a little bit more. But I would say most people would say, I don't want life prolonging procedures, but I do want to be kept comfortable. And that does mean putting an IV and delivering hydration if needed. Now, the other thing that I see that a lot of living wills don't address is dementia or Alzheimer's disease. So what that's saying is if you get a diagnosis like that, that's not considered a terminal diagnosis. So your living will would not be effective. But what we do is we include a paragraph that just says, if you get that diagnosis and you progress to the point where you lose the ability to swallow, that you're saying that you do not want a feeding tube put in, and that you understand that that may be activated outside the living will, meaning that you may not fit the traditional definition of terminal because you may live longer than a year, but you wouldn't want a feeding tube put in under those circumstances, and you would want your end of life decisions to be followed. So again, we're talking about the living will. So in our office, we have a healthcare power of attorney and a living will. They're two separate documents. This would be in your living will because the living will is effective if you cannot express your wishes and you have a terminal diagnosis. This is saying that if you would have the diagnosis of dementia or Alzheimer's, you would want your living will to be activated at that point, even though you're not necessarily under the legal definition of terminal. Now, before we move to the mental health power of attorney, I will say we also include a HIPAA release in the living will as well. So the healthcare power of attorney and the living will do have a HIPAA release in there. And the living will does not require your agent to acknowledge it in order for it to be effective. And that just means that, unlike the financial power of attorney, where your agent has to sign it before they can actually use it, under the living will, they don't have to, because the triggering event is you can't express your wishes. Okay, so again, you're welcome to provide your medical hospital staff, anybody who's treating you medically, you're welcome to provide them with a copy, as well as your kids or your agents that you've listed, because they can't have the power prematurely. Okay. So the last power of attorney that I wanted to go over is the mental health power of attorney. And this one is problematic. I will be very upfront about that. It's not my favorite document, but I'm going to explain why it's not my favorite, but then explain why we still recommend it. So the mental health power of attorney deals with two situations. We typically see it if we have a person who has a history of mental illness, or if we're dealing with someone who's aging. So we're planning for the second half of life, and we're in our 50s or 60s, and we know that there might be a chance that there's going to be some cognitive issues as we age. So it's usually used when we have a history of mental illness or to address dementia or Alzheimer's concerns. Okay, we do recommend that everybody have one, and the reason is because your agent under the healthcare power of attorney cannot consent or authorize experimental treatment, so drug trials, experimental treatments, things like that. So we need a mental health power of attorney to specifically grant your agent the ability to do that. Question I get most often is, why would I want my agent to be able to consent to that? And the reason is because there might be a drug that's making great headway that's labeled experimental for federal funding purposes. But again, you would want your agent to be able to consent to it. So if our thought is that we want to give our agent the maximum amount of powers and the maximum amount of flexibility, so that they can serve and protect you the best, then we want to have a mental health power of attorney allowing them to be able to do that. Now, the problem with the mental health power of attorney is that it automatically expires every 2 years. So if I would sign it today, 2 years from today, it would expire. Now, the only caveat to that is if I lose capacity in those 2 years, then the document does remain in effect. But if at the end of 2 years I do have the capacity to re-sign, I would need to re-sign in order for this document to remain effective. Our office, what we do is we keep a list when people sign it, and we send a letter saying, your near expiration date. If you want to come in and sign it, then you're welcome to do that. The mental health power of attorney can also be helpful in situations where we do have somebody who has a history of mental illness, and that's because it allows you to be able to state your preference regarding treatments that you're receiving, whether it be specific oral medications or any experimental treatments, as well as your preferences regarding treatment facilities if you would ever need that. So I would say most people who are doing it thinking of dementia or Alzheimer's planning, they may not have anything specific. And so what the document says is that your agent consent to whatever treatment or admit to whatever facility after consulting with your treating physician and determining that is what's in your best interest. If somebody has a history of mental illness and wants to have some preferences in there, we can tailor the document to allow those specific preferences. But I would say 95% of the people that I meet with are dealing with dementia or Alzheimer's concerns, and so they want to leave it as flexible as they possibly can. The other thing it does have in there is the medical records, the HIPAA release in there. So again, we allow the agent to be able to receive any information that they may request. The mental health power of attorney does require an agent acknowledgement. So just like the financial, where it's not effective until you as the principal sign it and your agent signs it, this is the mental health as well. So again, we always like the agent to sign agreeing to serve as the mental health agent. Now, one of the things I wanted to go over is, why do I need a power of attorney? And I felt like this was very fitting here because, the financial kind of plays in here. So even though we have a separate video explaining the financial power of attorney and what you need in it, I wanted to bring up this discussion as it dealt with the healthcare documents, because a lot of times we're dealing with long-term care planning. So someone's going into a facility or is already in a facility, and we're needing the power of attorney to be able to access information and make decisions. But one of the biggest misconceptions is that your spouse automatically has the authority to act on your behalf. This is really important here because the example I can give you is actually a husband and wife. They've been married for years, like I'm talking over 50 years. And husband was having some capacity issues, and wife would take him to the doctor. And the doctor's office wouldn't even allow the wife to be in the room when the doctor was talking to husband, even though husband had cognitive issues, wouldn't allow them because she had not been named as the agent. So we're seeing more and more aggressive rules about this, about not having access to information. I also had a situation where it was a younger couple who had actually just gotten married. So they were in their early 30s, and husband was in a motorcycle accident, and they would not provide the wife with any information because there was not a valid power of attorney. So again, we're seeing the medical profession be more and more aggressive here. And so it's so important to have these power of attorney documents for that reason. So if something should happen to you and you have the inability to make decisions and you don't have a power of attorney, then what your family has to do is they have to obtain a guardianship. And that's where somebody's petitioning the court and saying, hey, I should have the right to make these decisions for this person who cannot do that. On average, a guardianship can take about 3 months to get. And when you're dealing with nursing home planning and nursing home care, if we know that in Pennsylvania, the average cost of skilled level care is $10,732 a month, if it takes about 3 months, if we multiply that amount by 3, then that means there's about $32,000 that the financial power of attorney, the agent under there, can't protect. So if you're looking at trying to qualify for benefits and protect assets and you have to rely on a guardianship, then you know that you're already going to lose about $30,000. So again, the time and expense that it takes to do a power of attorney is worth it so that you can avoid having to get court intervention in order to obtain a guardianship and have the right to make those decisions. So again, I know that typically the financial power of attorney is the one who's dealing with paying the bills, so dealing with paying of the nursing home, but they do work hand in hand, because with medical decisions and obtaining a guardianship, again, you would want to make sure that you recognize that those nursing home bills are still going to have to be paid. And in order to pay them, you would need the financial power of attorney to do that. And if you don't have one, it could cost over $30,000 in nursing home expenses, and that doesn't even count the court costs. So where a power of attorney could be a couple $100, a guardianship can actually be a couple of thousand in order to be able to obtain a guardianship. So we always encourage all of our clients to have powers of attorneys. And again, we want it to be the financial power of attorney, the healthcare power of attorney, the living will, and the mental health. So there are 4 power of attorney documents that we recommend that every client have. So what's the next step? Well, I'm hoping that during this session you learned about healthcare power of attorneys, living wills, and mental health power of attorneys. And like I said, we always do free initial consultations. You're welcome to call our office at 717-655-2676 and request or schedule a free initial consultation. You're welcome to bring your documents along, and I would be happy to take that. Typically, we schedule an hour and a half of time. Be happy to take that hour and a half and actually go through the document and tell you what would I recommend those updates be if you need anything, or do you have the most updated language that you would need? So again, we recommend that everybody have those power of attorney documents. And again, we're here if you need us, and we do appreciate the opportunity to serve you. Thank you.